Any mention?
Yes.
May I please, Your Lordship? Your Lordship, I beg to mention item number 22.
Number?
22.
Your objection?
My lord, regularly they are taking time.
No, no
Your Lordship,
adjournment.
the conducting counsel is on sanction leave, Your Lordship.
Doesn't matter, you are there? Yes. Which contracting counsel?
MF Kurisi, Your Lordship.
1 week maybe, but no more chance.
Though objections have been raised for prayer for adjournment, as the contracting counsel is on leave, this matter of the 1 week, yes. Item 22, yes.
Highly obliged.
Yes, yes.
Lordship, I beg to mention item 21, Your Lordship. For 2
21,
weeks' time.
Mr. Jasantaj.
No
Sir, why?
objections, Your Lordship.
Yes.
No objections, Your Lordship.
You're for the respondent?
Yes, Your Lordship.
1 week, okay. Yes,
Much obliged.
yes. Yes, yes Mr. Jha.
My Lord, item 23, my Lord.
No objection, Lordship.
1 week, yes.
My Lord,
Yes.
let it 2 weeks, my Lord.
Why?
My Lord, some documents.
2 weeks, okay.
Please, Your Lordship, I beg to mention item number 29, Lordship.
Number?
29. I have informed the other side.
2 weeks, okay. Johnny Maraba, yes.
Much obliged, Lordship.
May it please, Your Lordship. Lordship, I beg to mention item number 32. Your Lordship, I pray for 2 weeks' time.
Yes, Lordship. Okay.
2 weeks.
Obliged.
Much obliged.
Hello.
May I please, Your Lordship? I beg to mention item number 33 and 34. I pray for 2 weeks' time, Your Lordship. Item 33 and 34. I pray for 2 weeks' time.
He's not there.
He's in another courtroom.
No objection, Your Lordship.
2 weeks, okay. 23 matter, yes.
Obliged, Your Lordship.
Your Lordship, I beg to mention item 27, Lordship. I pray for 2 weeks' time, Lordship.
Ritu Chinganom.
Ruti.
27?
Yes, Lordship.
Okay, 2 weeks, yes.
Deeply obliged, Lordship.
I know.
Yes, yes.
Please, Your Lordship, I beg to mention item number 28. Your Lordship, we're praying for 2 weeks' time.
20?
28.
Other side, who's there?
Sir Debnath, Your
You
Lordship.
bring consent.
Your Lordship, I couldn't find him.
Where's that junior? She was here just now. Where's Mr. Debnath? You ready with the matter? 28. Is Mr. Debnath ready with the matter? 28. 28.
28, Your Lordship.
No objection, Your Lordship.
No idea or no objection? 1 week, okay.
2 weeks, Your Lordship.
2 weeks, okay, 2 weeks.
Obliged, Your Lordship.
Yes.
Daily list, item number 1.
Yes.
Lordship, sir, DK Datta is in hospital, so I need
He's in hospital.
pray for 2 weeks.
For rejoinder, you haven't filed rejoinder affidavit.
No, Your Lordship. No, Lordship.
Lordship, I am appearing on for respondent number 2. Will be not filing order.
Yes, entering appearance today. First time.
I am appearing on behalf of Pooja Agarwal. P. Agarwal.
Your
For
file.
respondent 3 and 4, yes.
Formal party. Yes, your name?
R.H. Ellis.
R.H. Ali.
Ellis.
Eli. Ms. R.H. Eli on behalf of number 2 submits that no affidavit will be filed. The matter is pending for filing a rejoinder by the petitioner of the other affidavit. But however, as the counsel said, we unwell. This is matter for 2 weeks. Yes.
Item number 3.
Yeah, two is not connected at all. Just that time you wanted to reconstruct records. Number 2.
Item number 2.
Same place. We pass on this. Yes, this matter inadvertently was tagged with WC number 267. Stop. The matter is dealing. Yes, and to be listed separately. Stop. As per has been made on behalf of the ticket staff who still be unwell. This is matter for further orders after 2 weeks. Yes.
Much obliged.
Obliged.
3.
We all know about reconstruct records. Don't list together.
Please, Lordship. Lordship, I need some more time, my Lord.
No. How many times you passed it on that?
My Lord, there are 2 rejoinder I have to file, my Lord. I had some personal difficulties, my Lord. I could not concentrate on it.
Want to concentrate?
Could not concentrate, my Lord, of few days.
Why you lost your concentration?
No, I have not lost, but I could not give the concentration.
Because you could not deeply concentrate. Okay, this is a matter for hearing. We'll post it for hearing then. After 2 weeks, meanwhile you file your rejoinders. Yes.
Obliged.
Item number 4.
Who's the paying for the petitioner? None appears for the petitioner. Office note indicates that the service reports are complete. Entering appearance. Very good. Mr. S. Panthi entered appearance today on behalf of number 6. Such service complete. You want to file affidavit? He prays for and allowed 2 weeks time to file affidavit. None appears for petitioner. So yes. Newly entering appearance.
5.
All right.
File EB Pasa. 7 for 7.
State has already filed.
7.
We haven't
Why is
received.
sitting behind when the matter is called up?
Lordship, we have to receive instruction, Your Lordship, this matter.
You will be filing.
We will be filing, Your Lordship, 2 weeks.
What's the pension matter?
No, Your Lordship, areas for areas, Your Lordship. I think from 19, only for 5 years,
Yes.
Your Lordship.
What's the matter about? What's the prayer?
Your Lordship,
Areas of increments.
Yes, Your Lordship.
Is it affidavit necessary from your side? But then
It's necessary, Your Lordship, because he's last served at AG audit, Your Lordship.
yes?
His service, he retired from the office of AG only itself, Your Lordship.
It's from your office.
Your Lordship.
You finally rejoined her? No.
Yes.
What's your name?
W. Rambai. W. Rambai.
MSW Runbai on behalf of the petitioner submits that no rejoinder will be filed to the affidavit filed the state respondents. Stop MSB Pasa prays, however, has prayed for further time, for a 2 weeks time to file affidavit. This is matter for after 2 weeks affidavit by respondent number 7.
Item number 6.
Out here, same problem, Mr. Nan.
Yes, my Lord, rejoinder.
This is not the thing.
We'll give you 2 more weeks then. Since
2 weeks, my Lord.
what? How many times you've prayed once? Twice. It's a further 2 weeks time granted to the petitioner to file joint affidavit. Is thereafter.
7.
Much obliged,
Highly
Lordship.
obliged.
May it please Your Lordship. Your Lordship, we have just received the affidavit which is filed by respondent number 5 yesterday. So we'll be requiring 2 weeks time to file a rejoinder.
What about rejoinder? The other affidavits?
We have already received the affidavit filed by the state. So we'll be filing it.
Your name?
I Kharmuja, Your Lordship.
Mr. Akhar Mujai submits that as they have just received a copy of the affidavit filed number 5, he prays that we will be given 2 weeks time to file rejoinder to the same as also to the affidavit of the state respondents. Is this up to 2 weeks?
Highly obliged.
8.
Yes, MS Kolni.
Your Lordship, Ms. Kolni is on legs. Your Lordship, I pray that the matter may come up at the end of the board.
Yeah. After some time.
Obliged, Your Lordship.
9.
Your Lordship, I pray for some more time, Lordship, for counter affidavit.
I'm for the petitioner, Lordship.
How many times you prayed for time?
3 times, Lordship.
Only 3 times?
Yes, Lordship.
Why not filing affidavit?
Your Lordship, the respondent, she is not keeping well, Lordship, so she could not come to sign the papers.
It's ready affidavit otherwise. It's ready?
Yes, Lordship.
The MS and Kharshamlan prays for loud for the 1 week's time for affidavit.
Obliged, Lordship.
After is
10.
We filed the affidavit on the last stage, Your Lordship.
Well, Lords, 1 to 5 had filed the affidavit. Your Lordships had granted us time to file a rejoinder. Lords, we're still awaiting some instructions on this. Pray for a week's time.
While you file your affidavit.
I have no role in this matter.
Who are you?
I'm the municipal board.
That footpath belongs to them, my lords.
This is a footpath under section 63 of the Municipal Act belongs to us. Extension of road, creation of road, that is not within us.
Mr. K. Policy also prays for loud for the 2 weeks time to file rejoinder. Affidavit filed by the state respondents.
Yes, obliged.
I don't make any record, I won't be filing.
Yes, Mr. Philemon Nobri on behalf of respondent number 6.
6.
Submits that no affidavit forthcoming from the said respondent as they have no role to. So as they have no role to play in the matter.
Obliged.
11.
Lordship, I am the president of the VAC Chobribaris.
Where's Mr. E. Moomin? GA.
Lordship, I have applied for impleadment in the writ petition.
Who are you?
I am the president.
Where's the government advocate? Last time since 2nd of April there was no instructions. Last order was that instruction obtained positively for the next date. Who's for a petitioner?
I'm for the petitioner, Lordship.
Lordship, let it come at the bottom of the board, Lordship. I'll have to find out the file.
Yes. After some time. Your miss case is here for impleadment?
Yes, Lordship.
Or miss case?
Apply, Lordship.
12.
Take it up later. Yes.
Please, Your Lordship. Your Lordship, steps have been taken on behalf
Yes.
of all the respondents. We have already taken steps, Your Lordship.
Steps on?
On behalf of all the respondents, Your Lordship.
Two to four.
Yes, Your Lordship.
Yes, officer indicates that respondent number 4 since been served. However, self-report on 2 and 3 still awaited. Yes?
I'm for respondent 1, Lordship.
You want to file affidavit?
Lordship, I'll seek instruction.
What's the matter about?
Your Lordship, the petitioner herein, she is the daughter of the deceased, Your Lordship, claiming
Pension
that.
matter?
Yes, Your Lordship, claiming the pension of her late mother.
Yes, Ms. Abraham, so for we, why Dr. Mbuzika, please, that we have to receive instructions. The list after 2 weeks for affidavit instructions and for Service report response 2 and 3. Yes.
Deeply obliged, Your Lordship.
13.
State government is to cover the instructions.
Lordship, we are yet awaiting instructions.
What's the matter about?
It's a pension matter.
Pension matter?
Yes, he has retired in December 2023.
Well, it's still just a few months.
Yes.
3
When are
weeks
you going
time,
to come with
Lordship.
instructions?
3 weeks time, Lordship, may be given.
3 weeks too long.
It's 2 weeks.
Yes, Mr. Thaba, right?
Yes, Lordship.
Please was allowed for the 2 weeks time to obtain instructions to file affidavit. This
I do
thereafter also.
14.
I need some time to file my affidavit. I need some time to file my affidavit.
Your Lordship, I'm making a similar plea on behalf of the state respondent.
Second time's come. Yes, Ms. Adab not for respondent 2 and you're for 3 to 11. Then agree with 311. We followed for the 2 weeks time to file affidavit. This thereafter and so on.
Obliged, Your Lordship.
Obliged, ma'am.
15.
But this petition, my lord, is an abuse of process of law, my lord. But this issue of gratuity has already been decided by the division bench, my lord. In between, they file a contempt. That contempt was disposed of. We have pointed out to the court that we have complied. Another writ petition was filed, my lord, which was disposed of by your lordship, my lord. Very recently. Issue is exactly the same, gratuity, my lord. Now, what they seek to do is, my lord, they just change the prayer a little bit. Kindly have, if your lordships kindly have the prayer.
Yes. Will impose cost them, Señorita.
My lord.
If you abuse process of court, then where's the prayer?
Prayer is at page 19, my lord, the first prayer.
19?
Yes, my lord. In the last writ petition, the
Yes.
prayer was to comply with the order of the Honorable Division Bench, my lord. Now they have just changed it. They have just changed the order to our order, my lord, which is the compliance. 19-1-2021, which your lordships will find at page 60, annexure 5. This is our order, my lord, implementing the Gratuity Act, my lord.
Yes.
So, my lord, we have already passed an order to implement, and we have already paid the employees also, my lord, retired employees. Now, if some employees have not received their gratuity, my lord, they have the liberty, my lord, to approach this honourable court on individual capacity, my lord, not by an association, my lord.
See, Ms. Nyota, either will impose heavy costs.
Your Lordship, here, Your Lordship, they implement by Section 4, Your Lordship. But as per the award, Your Lordship, it has stated that there's award, Your Lordship, it says that we have entitled to 30 days, Your Lordship, in every year, 30 days. But they are implemented under Section 4 of Gratuity Act, Your Lordship, which is only says 15 days. And there is one section, Your Lordship, which is Section 4, subsection 5, Your Lordship. It says that it says that nothing in this section shall affect the right of the employees to receive better term of gratuity under the award or agreement or contract with the employer's Your Lordship. It says that. So we want to implement that Section 4.5, Your Lordship, should be implemented so that the award will be, we want as per the award, Your Lordship.
Which award of the Labour Court?
No, award is there, Your Lordship, which is...
Lord, kindly have the order passed by the division bench, my lord.
That's what page?
Lord, page 56.
Yes.
This is 2020, my lord. if we are applying the act, my lord, it is in toto, my lord, not in piecemeal, my lord.
And your lordship, when they apply this act, your lordship, they start picking up, your lordship. Some they get asked for the award, some they get asked for the payment of gratuity act, your lordship.
They have to come individually, my lord.
And your lordship, now your lordship, also we want medical reimbursement, your lordship, because as per the award, medical reimbursement is there, your lordship.
So after this order was passed, and this order 19 January 2021 came up.
Yes, my lord. And we have paid also, my lord, the retired employees, my lord.
You bring your senior, we'll have the admission hearing. Yes, objections have been raised by learned counsel for the respondent municipal board that the instanted petition seeks to raise the same issues which have already been decided by this court, and orders have already been decided by this court, and also orders passed by the municipal board itself in compliance thereof for payment of gratuity to the employee staff. In this view, this is a matter of admission hearing after 2 weeks. Because here to come. Okay. All right. Abuse of process of court, then.
All right.
16.
Ma'am, you'll be filing a counter.
Yeah, Your Lordship, we pray for some more time to file a counter.
What does this matter?
This is regarding
pertains
that.
to Millets in the challenge to the order of the Revenue Board by the petitioners Millets regarding registration of a label under the excise.
Okay, yes.
Well, as I enter appearance on behalf of the respondent number 4.
Who was that?
Tilak Nagar Industries. Well, the fight is basically between me and the petitioner before the Bombay High Court.
So what's happened? Why is Bombay High Court taking so long to decide that issue?
Well, it's too many complicated issues involved over there.
In this matter?
Yes, ma'am.
But another High Court seized with this matter, Delhi High Court.
Bombay High Court is seized of the matter. There are independent
Kolkata
proceedings
High
before the Delhi High Court, Kolkata High Court, because the law provides there has to be a registration under the Excise Act in different states.
Yes.
Now the principal dispute is before the Bombay High Court. Now in an injunction
Over
application filed by them before the Bombay High Court, there is a 100-page judgment which says that the ownership of that particular label brand lies with me.
No, but then they allowed some. There's a small observation there that if they registered at their own risk or something like that.
No, that is in my application, that is being heard currently before the Bombay High Court. I'm instructed, that hearing is going on right now. Because in their original application, we had filed a counter-claim. And in that counter-claim, this observation came.
That to register the brand
at their own risk and peril, but they cannot sell that product without the leave of the court of the Bombay High Court.
That means if registered here in Meghalaya, they can't sell it also without leave Bombay High Court? You have any instructions, or you don't know anything about the matter?
No instructions.
No idea. Who's leading you in the matter?
Sir Shivashish Sen.
Mr. Sen, I think,
He's on sanction leave today.
He's on leave. Well, it's at this stage, I'll pray for some time. Your Lordships have seen the sheer size of this file.
Size of the petition.
Size, but the...
Well, I would pray for 4 weeks, to allow us to file a counter affidavit.
And they will annex a lot of documents which are in French also.
Which are,
but then, are they
not
very
legible
material?
also, Your Lordship.
Not legible and,
The main document would be those 2 orders of the Bombay High Court.
When is Mr. Bashi coming back?
By next week he should be here.
He's on holiday?
Yes, he's on sanction leave, my lord.
Yes, you enter appearance on behalf of?
This one 4 minutes.
Mr. The Tilak Nagar Industries.
Tilak Nagar Industries.
And its pro forma respondent, CMJ? Mr. K.
But the service has been
so and so at an appearance today on behalf of number 4.
We have taken steps upon the respondent.
On CMJ?
Yes.
Yes, none appears as 114 who praised and allowed 3 weeks time to file affidavit. Stop.
Let it be 4 weeks.
The state also, Your Lordship, will pray for this.
The sheer size of this will take some time.
For 4 weeks time to file affidavit due to the voluminous nature of the pleadings. Also indicates that respondent number 5 is yet to be served. So list after 4 weeks for affidavits by the state respondents on number 4 and for appearance of respondent number 5.
Right.
17.
Lordship, instructions are awaited.
Your
Instructions
Lordship,
are
I'm appearing for respondent number 2 and 3. I pray for 2 weeks' time, Your Lordship, to file an affidavit.
2 weeks time to file a
affidavit, Your Lordship.
Mismatch of PAN card.
Mismatch of PAN card.
Oh yes, already there's an interim order in your favor.
Till today.
As per 2 weeks time, after respondent number 2 to file affidavit. Stop. Interim order pass LSC continue till next date.
Highly
much appreciated.
Second call, item number 8.
May it please the Lordship.
Yes,
My Lord, as per the impugn order, we were to call upon a meeting with the petitioner. So, my Lord, we couldn't do the period Lordship has given us for 1 month time. We have already called.
Contempt.
My Lord, it is a contempt petition, my Lord. So, direction of the Lordship in the impugn order was to have a meeting with the other side. The petitioner is claiming for bill, my Lord, for the work he has rendered with the MECL, my Lord. So, my Lord, the bill which was enclosed the writ petition, my Lord, those has to be approved and verified. So, my Lord, on a limited issue, Lordship has directed the MECL and the petitioner to sit together and verify and then to come up with the actual amount, my Lord. So, it was, and 1 month time was given. And we did not call for the meeting that was which the complaint has filed. So, now, my Lord, I have been informed that a meeting has already been called in compliance to Lordship order, though there's a delay on the 10th, my Lord. This is a copy. The petitioner has already acknowledged also. We have already called, my Lord, telephonic conversation also we have already conveyed. And this is the email, my Lord, through which, and he will be coming on the 10th, Friday, my Lord. So, my Lord, my prayer is that, my Lord, we have complied with the order of this Lordship's order, my Lord.
Where's the letter asking for fixing the meeting? Is there with you?
No, my Lord, there was an order directed by this court to call for a meeting within 1 month.
No, yes. I mean, like where you fix the meeting now with them?
My Lord,
when's the meeting fixed?
My Lord, in the office of the corporation.
Oh, when?
On the 10th, my Lord.
We don't have any instruction, Your Lordship.
My Lord, if the client doesn't inform them, we are in touch with them. We have already called them, so that cannot be the ground for. They could have they could have spoken to them yesterday also.
Instructions that in compliance with orders of this court.
4/3/2024.
With the petitioner, stop. He submits that the slight delay.
My Lord.
How long was the delay in calling for the meeting?
Lord, the order was passed on 4th March, so we were supposed to call by 4th April.
The slight delay is.
So we are in May now, my Lord.
Inadvertent circumstances.
A month's delay, my Lord.
Yes, so the matter you take instruction this tomorrow.
Yes, Your Lordship.
MS and Raji to obtain instructions. This is a matter tomorrow.
Day after tomorrow, Your Lordship.
Why?
Tomorrow, my Lord, tomorrow is the meeting. Tomorrow is Thursday, 10th is Friday is the meeting, my Lord. So it will be proper to have this matter tomorrow, my Lord.
Tomorrow you take instruction over.
Otherwise, it will affect the meeting with the body also, my Lord.
11. 11.
Lordship, the conducting counsel is not before this honourable court today, Lordship. And through telephonic conversation, it seems he's not aware as to whether instructions have come on her Lordship.
Who's this A Moment?
Mr. A Moment is in the same chamber with Mr. S. Sen, Lordship. Not received any instructions, Lordship.
What is your prayer and petition?
For conducting election, Lordship.
And who are you?
Lordship, I am the president of the. I am the president of the
Of the subsisting VC?
Yes, Your Lordship.
Is already terms already over?
Lordship, the term is over, but actually after the over of the term, so I have been allotted 45 number of works. So in that project, I have engaged my personal money. Almost it's a huge amount. So if Your Lordship may allow to file my affidavit.
Where's the pleading? You are not impleaded as yet. You object to impleadment.
I'll seek instruction, Lordship, whether I'll object or not.
You are and this case number 57 of 2024 and LPC number 82 2024. This is an application for impleadment of the, what's your name?
RHLs.
Not your name, name of the applicant.
Chandra Mohan Das.
To implead one C. Chandra Mohan Das, who is stated to be the present president of Sobri Bari, SOBRI-BRA-VEC, under Salsala Scene RP block. Stop. The ground for seeking impleadment is तो forget करता cancel करना तो हम तो Yes, sir. Where's Mr. Sheikh?
He was out of station, Lordship.
Forgot your name, sorry.
Yes, Lordship.
Your name?
Ellen Aring.
Aring, yes. Mr. Ellen Aring, on behalf of the petitioner, please, on behalf of the petitioner, please not to obtain instructions and to file objection when necessary. Just after 2 weeks, yes.
Much obliged, Lordship.
Obliged, Lordship.
Hearing item.
In the main case, this is after 2 weeks. Yes. In the main case, the conducting counsel, conducting government advocate, conducting counsel, that is government advocate, is not available today. Stop the senior government advocate who has appeared on his behalf submits an instruction awaited. Only this is matter for 2 weeks. Along with the miss cases.
Much obliged, Lordship.
Yes.
18.
May it please your Lordship. Lordship, Senior Conducting Counsel wants to make some submission, Lordship, in this matter. So kindly take up this matter.
Who wanted to file?
Affidavit, Lordship.
Short reply with the short reply.
Yes,
File.
Lordship, learned DSGI will make his submission,
Yes?
Lordship. Learned DSGI will make his submission in this matter, Lordship.
No, who wants to file short reply?
Respondent number 1 only, Lordship.
We prayed for time, Lordship.
Respondent number 1 only, Lordship.
You file it. It's getting unduly delayed now.
Lordship, may kindly take up this matter at the end of the board, Lordship.
You ready with the matter?
No, not today, Lordship.
Then? Because they haven't filed short reply.
Yes, Lordship.
MSA Pradhan, what submissions he wants to make? You're not aware?
No, Lordship.
Other parties are all there present.
I pay for the same respondents.
4, 5, 6. A short reply as spread. Though a prayer had been made on 24/4/2024 to allow the respondent to file a short reply, the same is not yet on board. Stop. MSA Pradhan submits that the learned senior counsel appearing wants to make few submissions. What submission do you want to make? Won't record that. We listen after.
2 weeks, Lordship.
Naturally, they won't be prepared today. They were waiting for a reply. Just after
2 weeks, Lordship.
2 weeks? Becoming a joke. Yes, after 2 weeks.
Obliged, Lordship.
Highly obliged.
19.
May I please, Your Lordship? I have prepared one brief facts of the case.
Where's the brief facts?
Yes, sir. Along with the judgment and...
You've given him a copy?
Yes, already given.
Will you send it? Yes. What judgment is this? I don't even read. It's so small.
Your Lordship, a main book is also very small.
The main book very small also.
Yes, it's very old, 1951 judgment, Your Lord.
No, 2009 3J. This one 50. Oh, yeah. Yes. 51.
Yes, so it is very small, and only thing is that it is recorded that Patta once issued, paragraph 3, Your Lordship. Paragraph 3 of this judgment, Your Lordship, that Patta once issued cannot be cancelled, Your Lordship, unless there is a default in payment of tax and all.
Why by suit it can be cancelled? Why can't be cancelled?
But it is on, because Your Lordship, same judgment is recorded in another this GLR 2009, Your Lordship. Because the petitioner has been all along in possession for last 25 years, Your Lordship. And suddenly in 2015 they started filing cases.
Okay, yes.
Lordship.
Now, just to refresh that, you had filed a suit in the village court, correct?
Lordship.
You said that you are the descendant of
adopted.
the
Adopted daughter.
of these two persons.
Yes.
And then you were driven out sometime in
yes.
1992.
Yes.
Driven out by?
By the husband of
the petitioner.
Yes.
He drove you out.
True.
He drove you out, and then the husband of the petitioner got the patta issued in his name.
Lordship.
It was issued in his name.
Yes.
Then after the issued his name, he died.
He died.
Then it's already transferred to the
May I please, Your
to the
Lordship?
petitioner.
Before he died, he transferred all the
Before
properties in his
he transferred
in the name of his wife.
The patta name of the petitioner. Now you filed in the village court. You didn't give a copy of the plain to her also.
No, we have given.
No, Your Lordship.
No.
That they
Let
denied.
me ask him. Yes. All the papers were given.
All the
They
papers were
contested the
given.
case.
It is recorded. Their statement also has been recorded. There was a proper trial in the village court, and opportunities were given. And then after that, that order of the village court was set aside by the subordinate district council court.
Okay, then
thereafter
then,
we
then
filed.
you allowed the degree in your favor.
Yes.
Correct.
Yes.
By the village court. Then they appeal against that.
Yes.
And the order of village court is set aside.
Yes, in the district council court, yes.
Set aside. Then against that setting aside,
yes.
even before the judge council
Yes.
court, who
Judge-
upheld
judge upheld, yes.
the order of the village court.
Village court.
Okay. So now this is essentially a second appeal.
Yes.
Right, or third appeal.
Second, they are filing a criminal, the civil division. Yes.
Yes.
Now, my lordship, my only point here is that this is a criminal division. There's a various
Not
judgment.
criminal division, civil
civil division. Like, sorry. That limited as per the rule, lordship is very much aware. I have various judgment. I have brought it. I will place it before the court also. And there are 2 or 3 judgment from this court only, from the division bench as well as from the Supreme Court. It is very clearly and categorically stated that review limited of the scope of review is very limited.
Scope of review, scope of revision.
Revision is, yes, revision is very limited because they have to only to see the nature of any error of the judgment. But here in this particular case, in the order dated 11/12/2018, Judge of the District Council Court, he has passed an order while filing the order, passing the order, as much as 5 issue has been framed. Then or regard
the second appellate stage.
Yes, in the appellate stage.
Okay.
Then each and every issue has been discussed. Whether I am adopted daughter, and whether there's even discussed on limitation, and it's also discussed about whether the as per the Garu customary law, whether the son can inherit the property. All those this has been elaborately and detailedly discussed.
Suppose they're only sons, what do they do?
If there is only son, if there is no adopted son, then that is a different case.
Adopted son, no adopted daughter. Now the daughters are deserted and gone away. What will the parents do?
Then, if that is the case, then the Mahri clan's member will take over the property. If no one is there, even if there is not even a son, not even the adopted daughter, if that is the case,
Suppose
then
the son is there.
If that is a son, if there is no adopted daughter, if it is only one son, then obviously the property will go to son. But here in this case,
you see, this case, from what I see, is that there were 2 brothers.
no, there is no 2 brothers. There is another is relatives only. He has only one son.
These people who died,
Yes.
I mean whoever the names are, they had 2 sons only. One son's married to the petitioner. Correct?
Lordship.
So your case, your adopted daughter.
I'm the adopted daughter.
You are Bensila Sangma.
Bensila Sangma. I've been staying since from 19 around for the year of about 25 years. 1987
to 1992.
Yes.
That's 25 years.
25 years. From 19 they never dispute this fact. Even
87, but 92 you said you're driven
1987 away. I was adopted.
See, my old notes there. 1992 alleges she was driven out.
Yes.
Then
5 years only.
during lifetime of husband, so-and-so properties material name of petitioner. So 92 you driven out from there.
Yes. Yes. After the death of my
note
parents.
of mine last hearing that she was adopted by the Patadar in 1987. Correct. 92 you driven out. How can you stay 25 years? That's only 5 years.
Yes, 5. 1987 is in there. Community no payment issue expired after the date of
then so you said 5 years after adoption 5 years.
No, Lordship. Here is a
because
yes, yeah. The page 39 of the of their petition. They have stated before the Court of Judicial Officer, Para 2.
1 second.
Page 39.
1 second.
Lordship.
Page 39.
Page 39. More than 14 years. May just there is Para 2 they have categorically mentioned.
Yeah.
That since may I read your lordship, that since the late Ginseng A. Sangma and late Kumudini Shet Sangma have no female issue of their own, therefore, in the year
This is your statement.
Yes.
His rejoined.
This is
He
our
rejoined
statement
her.
before. This is our statement before the court of the subordinate officer.
Yes.
1987, they have adopted Srimati Bensila Shet Sangma, defendant, daughter of late Sunendro M. Marap, and Srimati Meljoni Shet Sangma. Srimati Bensila Sangma stay with her adopted parents for more than 14 years, until she was driven away by late Prince Shet Sangma and his family.
And
14
evidence,
years.
it has been substantiated by evidence. This one has been proven. This, as she
Yes.
stayed 14 years.
Yes.
Has evidence been collected that yes, people tested in evidence that she stayed for 14 years.
Yes, in the issue framed by the judge of the district council, they have mentioned lordship in the issue number whether the scheduled property, customer relo property. Yes, they have discussed your lordship. This is page 74 somewhere. They have mentioned with regards to the issue number 2. Yes, speak Garo. Whether ancestral property can given to the son, and the female issue Garo who will inherit the properties, whether it need to be decided, whether property given to Garo son need to be. Of course, that evidence as with regards to 14 years, that is not there. But even when they file an appeal before the judicial officer of the district council court, they also have never raised this issue before while filing the appeal against the order of the village court, Your Lordship.
Now, when this Princeton, no?
Yes, Your Lordship.
When he was given the land by the parents or whatever, when he took Pata, there was a...
Since during their lifetime it was given to him, and after their death he transferred to his wife, and mutation also granted by the district council court, Your Lordship. Annexures are there.
By transferring the land, they have not taken the Mahari's concern.
But Your Lordship, proper notices were issued, but these are not part of this civil division. I have the Xerox copy because...
See, the thing is that if we have to interpret Garo customary law, it's like this. Now, we have to, even though issues have been framed, but whether, during the lifetime of a parents now, whether a Garo man can inherit or be given property by the parents, that is one, and if that is done with the consent of the charas and chachis or whatever of the clan. So if he gets a property, whether it's up to him to, or he has to return it to the, or after his death, it returns back to the clan.
Yes.
What is the position?
See, my reply, Your Lordship, my humble reply is, even that issue has been discussed, because now the petitioner here in the private respondent, we are the, and not only the private respondent alone, the entire Chicham, they call Chicham Mahari, is denying that he has fraudulently, without the knowledge of the Chicham Mahari, without their consent. Yes, they are prepared. That is the case. Otherwise, if we are giving wholly with the full consent of the Mahari, then we have no problem. But here is the case, my lord.
That is what this court wants to see, evidence that has come out. Whether, firstly, what is your right? Now, your right is that you say that you adopted in 1987, right?
Yes.
And as per your story, is that you stayed for 14 years. Now, what kind of adoption, we don't know. But how long you stayed, and whether you really stayed with them, has it been given anywhere in the evidence that, yes, that Bensila Sangma was adopted daughter of this, what's the name of the parents?
Kumudini and Prinsen.
And Kumudini and so-and-so? Now they say you driven out 92, you deserted, you went away.
No.
Now becomes very complicated. Suppose you deserted and went away, whether you still retain any rights. You might be adopted today, you ran away tomorrow.
We in our case, we never run away. The private respondent here, she never ran away. She was there. And she was there by force. We have, in our all pleading, since from the village court.
How old was she when she was adopted?
When 1987, around, when she was still before 18 years.
May I please, Your Lordship? I beg to
just one more submission. One more. Now, the issue, well, my learned, Your Lordship is asking that whether those evidence, the petitioner has supposed to raise all these issues before the judicial officer while filing the appeal against the village court. But they have never raised all this issue. However, now it has gone to the judge of the district council, since the subordinate district council court, the ordinate court, has never framed the issue, never lead the evidence, and then just pass an order.
So basically, is that whether you adopted daughter or not, number one.
Yes.
And whether why after your adoption, whether you deserted or not. So if you deserted, when your rights are relinquished also.
No,
how can you take advantage if you adopted in 7, you ran away, and then can you come back after they die and say that I was adopted daughter? And if the patta has only been issued in the name of the son who was there with the parents?
No, Lordship. My case is I never ran away. I never deserted. I was there with the parents since from 1987. Since after that, when my parents died.
When did they die?
They have died since 19. Yeah, they have mentioned.
May I please, Your Lordship? His parents were
then
nothing is there.
No, his parents
means adopted yes, then 92 and 93 respectively they died. And Your Lordship, I beg to differ with my learned friend, because annexure 2 type copy, Your Lordship, she was adopted at the age of 9 and 10, whereas my learned friend is saying she was below 18 years. She was 18 years, but 9 and 10, and she stayed for 5 years. That is when, yes, Your Lordship. So 87, had she been 9-10 years in 87, 5 years, then 10 plus 5, 15 years. Suppose she was 15 years when she left the house. From 92 to 2015, all these years, no one appeared or any complaint, nothing. When everything is completed, land transfer, mutation done, then they filed the title suit.
Even then, suppose she has some right, then that should be examined.
But this,
whether the thing is that we have to examine the.
Your Lordship, record is there, but I do not find any that village code there is any evidence taken. Just it is in the order it is reflected that it is a full dress trial has been. Whereas she was. Yes, it is recorded somewhere that it is full dress trial has been conducted by the village code. Yes, Your Lordship. But no
copy of the.
Yes, no copy, Your Lordship. No copy of the plaint is given to the petitioner. She could not defend her in the village court, Your Lordship.
No, but one thing, when you file the case village court, you let evidence.
Nothing, Your Lordship. Village court, it was filed by him only,
Did
Your
you read
Lordship.
evidence out there? Was evidence led?
Yes, as per the order.
No.
Order.
Yes, we are.
As per your information, as per the records, when you filed the suit to stake your claim, did you come forward and tender your evidence, and were you cross-examined by the opposite party?
Yes, we have asked some. The village court have asked some people, like the close relatives of the both parties. They
never examine you.
They have examined me also.
So what did you say?
Then I have stated that I am the adopted
deposition
daughter.
is there in record. Is any deposition? Deposition means recorded deposition. Your deposition, her deposition, is there on record or not?
It will be there in the village court, my lord, because now.
No. See, Mr. Sangma, I'm asking whether deposit recorded or not. That means, as per instructions, did this Bensila Sangma, when she filed the suit to claim the property which has pata been issued to the petitioner, when you went to stake your claim, at that point of time, after you file your plaint and issues maybe frame, not frame, were you called to give evidence as to, to give your oral evidence? Did you give evidence or not?
I
recorded.
As per the instruction,
and you were cross-examined also? Or no lawyers appeared in village court?
Actually, in the village court.
Without plaint, she appeared. She received the summons, she appeared.
Then?
But order is passed. It is almost ex parte, Your Lordship, because she was denied the opportunity of filing her reply.
Sangma, we won't send it back to village court. We have to send it back to the court judicial officer. Let him try de novo.
Yes,
then frame proper issues.
Yes.
Taking Garu customary on consideration. How old are the parties now?
She is 65, more than 65. Last year when I filed evidence,
around 35, 30.
More than
See,
35.
On the basis of materials
42
here,
she will be around.
very difficult to
Yes, Your
decide
Lordship.
whether you adopted, whether you ran away. Now, if firstly it has to start from the fact that whether you adopted or not, whether you deserted, those are the things, and whether the grant of pata to the husband of the petitioner was with the consent of the other clan members. Then, if there was consent of other clan members, then it gets over. That means you don't have any
Lordship,
case.
if that is the case, then this matter can send it back to the village court.
We won't send the village court.
Not village court.
Mr. D, we'll send it to the judicial officer, I think.
Judicial officer.
Because on the material record, we can't.
My Lord's attention to two things. My Lord is very much aware of J. Sangma's book, where my Lord says
Principles of Garo law.
Yes, my Lord. He says, my Lord, two things that is very pertinent here, my Lord. One is how an adoption takes place, my Lord. I'll just read out one or two lines, my Lord. When parents have no suitable daughters or daughters at all, the mother looking for her maternal relative to adopt one. Usually the choice falls on the daughter of the actual sister. Now, my Lord, it has to be ascertained by evidence whether Mr. P.T. Sama's client
is the daughter of
the sister or not. Second thing, my Lord, the position of an adopted child. The adopted child, whether son or daughter, are entitled to full status as a real child of an adopted parents of all purpose. That means, my Lord, adopted daughter can inherit.
That is known.
But they also says, my Lord, they shall inherit or may forfeit that right by subsequent conduct. Now, if in case he was chased away or he left the house, the conduct will say that she cannot inherit the property, my Lord. Now, for that, my Lord, evidence is very pertinent.
Because if you say she's only 9 or 10 years old, she's adopted 87. So that girl was only 15 years old when the adopted parents died. So that also will be difficult, because then she won't be aware of,
Yes.
But then you were driven away. Driven away is, if you see you were driven away, that is, goes in Mr. P. Sama's client's favor. That means she wanted to stay, but you say she's driven away. But whether she's driven away or not, so I don't know.
That is, my Lord, may you kindly see page 31 of CRP, my Lord. Page 31 of this is a village code order.
Yes.
Here, my Lord, they have not stated anything that she was driven away. This is the village code order. Otherwise, in the village code order, my Lord,
Page
31, my Lord. This is a type copy of the order of the village code.
2.
Yes. They only say that his daughter-in-law, they can't enter the property.
Yes. So driven away, my lord, maybe after thought.
No, in our pleading we have mentioned, Lordship.
But that evidence has to come, my lord. And evidence, my lord, probably, my lord, my humble understanding, my lord, village court, they are not in a
They'll not
position.
be equipped to. So what to do, Mrs. Sangma? Because on the basis of both of you seem to have a good case.
But
so flip a coin.
Lordship, but the limit, the scope of the revision is very limited. Now we cannot go for reappreciate evidence.
We are not reappreciating evidence. If the matter is totally irregular, the whole matter is illegal, it looks without jurisdiction, the order has been passed, the court has ample power. Don't go by. Order 6 is much larger. With due respect to some judgment that have been passed, Order 6, I mean that over this is council jurisdiction, the council code rules, under which these applications have been filed. It can be equated to a revision of 1.5. Though the division bench has held, we can distinguish it. I know what judgment you want to place. That is like we are aware of that. That's the thing. But if it's not 227.
Just a district.
They have filed.
It is under Rule 6, Your Lordship. Under Rule 6. Rules. Application under Rule 6 of the Meghalaya High Court. Jurisdiction about District Council Court.
He also filed a writ petition, Your Lordship, in the same case.
Writ petition because my patta was cancelled. But the order, Your Lordship, may kindly have a look at the order. By which order they have cancelled my order, patta, Your Lordship.
And the next one. So this one on the facts of this case, very difficult to come
decide
to
whether
in first court to come and to uphold the order or to to dismiss or to uphold the order or to allow the case.
Without evidence, it will be very difficult to appreciate the.
See, one thing, Mr. Sharma, is that Para 4 and 5 6 schedule has given you certain protections with the applicant of the spirit. Now, even the notifications issued by the government that says that notwithstanding the application of CRPC, CPC in the procedure to be adopted by the District Council courts, they will continue to exercise powers in the Para 4 and Para 5. That means that is still there for the Council courts to go into other things so that to come in the interest of justice. Yes, which paragraph?
Your Lordship, read petition number 256 of 19, Your Lordship, last page, Your Lordship, annexure 57, page 57, annexure 8, Your Lordship. Page 57, by which District Council has cancelled the patta.
So who is in possession of the land now?
Land is now, actually, till cancellation of patta, I was in possession since 93, Your Lordship. 2019, but by order dated 25th June 1919, my patta has been cancelled. There's a direction.
There was no stay of this cancellation.
Earlier, Your Lordship, it was stay was granted by this honourable court, but it was not renewed.
By whom?
Because no prayer was made on behalf of the petitioner. Earlier conducting councils never prayed for Your Lordship.
There is no, basically there is no stay.
Yes, there was a
but
stay order.
They have
was
never
there.
prayed for the continuation of the stay of this order.
I'm admitting.
The first order.
No. Now the thing is that
I'm admitting that there is no continuation of this order. Your Lordship, kindly.
It's the page 57, annexure 8 of the petition.
Order is there. But this order has to go because, Your Lordship, this is a wrong order. By which they have cancelled this order, Your Lordship, kindly have a look. (14.7.17), it is in my favour, whereas
there was a miscase for stay of the.
This is not miscase.
In order, no.
Not there.
It is
not reflected in the main on the order sheet also. That is also
yes.
stay.
Yes.
There is no miscase, my lord.
No miscase, Your Lordship, I am admitting,
There
but there was a order.
There was no prayer for stay also.
Status quo granted on 18/7/2019, Your Lordship. Just noting is there. 18/7/2019 status quo granted in this petition, Your Lordship. 18th July 2019.
Status code where? In the civil revision application?
Status code granted, Your Lordship, I do not
There's
know.
no order 18.7.
Your Lordship, since there is no continuation, I am not praying for that. But only this thing, Your Lordship, this order by which they have cancelled my patta, this order is wrong order because, Your Lordship, can't you have a look at the order?
Office order 25th June.
Yes, Your Lordship. By which they cancelled, this order dated 14/7/2017 is in my favor. But this order they have noted.
Confusing with
14/7. Page 33, 35, 45.
order dated 18.7 is saying.
Yes, Your Lord. No, actually it should have been 11/12/18, but instead of it is recorded 14/7/2017, by which it is hereby cancelled. Because 14/7/2017 is passed by the judicial officer, Your Lordship, in my favor.
No, 18.7/19 there's no stay order.
No, Your Lordship, I am not praying for staying.
In terms of regard of possession only.
Yes, Your Lordship.
No, out of the property.
Now just it is lying, still staying, but
No, now this property is in none of this possession because we are also not using.
no,
They
she
are
is
also
staying there. It's a half
we are not
residential
staying at all.
property and half agricultural land. In the
Half is staying also.
she is staying.
You are staying there also.
She is the petitioner. I am not, Your Lordship. My client is staying there.
I'm saying you are staying means you are.
Yes, yes.
Why
Yes,
should
Your
you
Lordship.
be staying there?
Yes, Your Lordship. Sorry, Your Lordship. Petitioner is still staying because it is a half residential house and half agricultural land. Big land, Your Lordship.
I mean, if it's coming with asking questions, but the court becomes difficult.
Sorry, Your Lordship.
Why should you want to stay there?
Since this order has been passed by on 25 June 2019, that the whole entire civil revision petition filed by my learned friend has become infectious because there is no order staying this order and
Why infractuous?
Because order has been passed because on the basis of the order passed by the district council court, it has been executed. That patta has been cancelled.
Very good, Mr. PG Sangma. That means that why the suit needs to go for de novo? Whether within cancellations, right? Cancellation is a consequential order to the order of the Judge and Council Court, correct?
Lordship.
So they just acted on the order of the Judge and Council Court and find that he has no right, cancel the patta. Now suppose she can set up a case now that she's, she has the right and the patta should not be cancelled and should be in a decree of the court will come, then you have to follow that decree also. So it can't be said to be infractuous CRP. How is he infractuous?
But this particular
that argument, what kind of argument is that also?
But
yes. Yes, okay. You take down.
One more thing, my lord.
Yes.
This writ petition. This writ petition, which they are challenging this order, cancellation order. Whether this petition, we are questioning even whether it is maintainable.
That petition, this one, will be kept, this entire thing kept abeyance, status quo will be maintained as on today, awaiting the outcome of the suit, that's all. And if the orders are there that yes, she's rightful, she's the rightful person to be issued the patta, then you have to because the order of civil court overrides the revenue court. Revenue court patta is what? Patta in fact is just a record of the
at the meantime, Lordship has correctly pointed out. At the meantime, because now this particular property is none of us under possession because neither I am possessing.
Why don't you share it then?
I mean, no. My contention is if the matter is remanded, then
can you bring a settlement? You share 50-50, then you avoid this entire litigation. You share 50-50.
Yes.
Go for another 10-15 years litigation. We can't help it. Court has to go in accordance with law, and as per the materials, there's nothing to show, to establish or like to 100% establish the rights on favor any party.
It may be, Lordship, may be reflected that way. I will try to advise the client. Let them say the 50-50.
Say that, no?
No, Your Lordship, I have no instruction regarding. She is a very old lady.
No, we take 50-50, I'm saying. You
No,
take
Your
instructions.
Lordship, because
You won't take 50-50.
I'll have to seek instruction through someone, Your Lordship, because I have no direct contact with the party.
No, I'm saying because
then how is standing
50-50, I have no problem because it is after all is for her interest also, for my interest also.
Yeah.
If there is a negotiation come for settlement, well and good. Otherwise, they will come again. It will go back.
Is that it goes back. This is just to bring about some kind of a quietus to the entire issue. Now you've been some village court been fighting since. Since how many years now? Gone to the first judicial officer, gone to judge council court, gone to council court, patta cancelled, patta issued. Here now it's been lying since 2019.
2019.
Yes.
So in that
Just
event, Your
because,
Lordship, give
the
me some
records were
time so
called-
that I can seek instruction regarding that whether it can be.
Take down.
So your order maybe.
In the course of hearing, it is seen that in the proceedings before the village court where's that order?
Order is at page
69.
20.
No, in your CRP.
CRP past order, village court order is 26, page 31-32, Your Lordship, type copy. Page 31-32.
Page 31, type copy 31.
Yes, from the village, it is seen from the materials that the proceedings before the village court no evidence was led to establish positively the rights of the respondent who had instituted the suit. Stopped. The order dated 10/12/2015 only speaks about the application of Garo custom without applying the same to the facts and circumstances of the case that had been brought before the village court. Stop. An appeal which is an appeal which was preferred thereafter before the
this BS judicial officer, Your Lordship, page 43. Judicial officer, first class magistrate, first class subordinate.
without applying to the facts of the case, applying it to the facts of the case that had been brought before the village court. Stop. The said order also does not reveal as to whether the petitioner was given adequate opportunity to present her case. Stop. In the appellate order, where's the appellate order?
First order is at page 43, Your Lordship, type copy, annexure 3.
In the appellate order, page 43.
Page 43, annexure 3, dated 14/7/2000.
Page 43. Appellate order.
Appellate order is page 69.
Or the judicial officer.
Judicial officer, first judicial officer order.
Judicial officer order is at page 54, my lord.
Okay. Set on the ground of
there is no
limitation,
no,
correct?
Limitation, Your Lord. She set aside the order on the ground of limitation.
Okay. Yes. On an appeal preferred therefrom,
Civil appeal number 4 of 16.
being civil appeal number 4
Of 2016.
2016, the Court of Judicial Officer and Magistrate First Class, Judicial Officer, District Council Court, Tura, by order dated 14/7/2017, had then set aside the order of the village court on the ground that the suit was instituted after 21 years as against the legal requirement of filing the same within 12 years. Stop. Thereafter, on a further appeal which was preferred against the said order, the Judges Council Court then in misappeal case number 7 2017 by order 11/2018
Last page, set aside the order.
on the finding that the subordinate court had failed to discuss serious issues and had passed impugn order, had failed to discuss serious issues, the court of the learned judges, council court, again by discussing Garo customary law, upheld the appeal, allowed the appeal, allowed the appeal, set aside the order of the judicial officer, subordinate to council court, and upheld the order passed by the village court dated 10/12/2015, and further directed for cancellation of Pata suit lands. Even here, no evidence was led in before the judge.
No, because before the judge, this is no evidence only.
No, he just framed issues and
yes.
said himself. Yes. Current come the deposition. Come the deposition. I've not found any deposition anywhere. That is a disturbing part of the full case. You're not allowed to present your case also, or she was allowed to present their case. What they did was they said, the Garo customer says this.
They discussed the
permissive possession is allowed to the son after that, unless the clan decides. So,
but only thing is that, Your Lordship, when this order was passed, this law of limitation is applicable to throughout the state of Meghalaya by the order passed by the
That's why this court is trying to find a middle path.
Middle part, yes, Your Lordship.
That you share a property if it's possible, then you.
I'll seek an instruction, Your Lordship.
Court. We don't want to make this kind of court. So they also, judge also didn't call it for evidence?
No.
Yes, Your Honor. It is noted that in the entire sequence of events, in the entire sequence of the proceedings, right from the village court till the court of the judge, the parties before this court had not led evidence at any point of time. Stop. In this view, the matter, as the proceedings were not compliant with the fundamental principles of judicial procedure, it would be expedient to relegate the parties for a de novo trial before the Judicial Officer District Council Court. Stop. However, looking into the aspect that the petitioner is since aged and that the property is lying waste presently, waste, W-S-T-E, without anyone looking after it, correct?
Yes.
Lying waste without any person looking after it. As suggested by court and with the as suggested by the court, the parties are agreeable to
share 50-50.
Agree to try to come to an out-of-court settlement,
Lordship,
so as to bring a quietus to the entire matter and to avoid lengthy litigation.
In the meantime, Lordship, because now at this since that land is nobody should use, neither me nor that part should be make it.
Then who will go and cultivate it? How big is it?
Because I'm also not cultivating. They are also not cultivating.
No, isn't.
It is in the village, in the Muktangra. Muktangra. Because if they both a party, if any party come, then there will be law and problem. They may kill each other. They may.
The question doesn't arise if the statement of Mrs. Bhattacharjee is correct. That stage will not come, my lord. If she is in the possession of the land, by passing this order, my lord, that will complex the situation, my lord.
No, there's no one's possession, they said.
Yes,
no,
yes.
No, I'm still staying there.
No, the status quo then.
Yes, the status quo.
Status quo, Lordship, they may misunderstand, Lordship, because
now,
only say that both the parties should not cultivate. That only that one.
Cultivation is one thing, but your Lordship, my right of residence.
They are not cultivating. They are staying there, but land is. But they are staying in the premises. But the cultivation part, neither she nor me is cultivating.
Where are you staying?
We are staying. Actually, she stay in that.
No, you.
I'm staying in the Mukdara only, not in that.
How far from the land?
It is around 2-3 kilometers, like from here to like.
That's all right then. Yes or no? Unaccepted by the parties. An attempt will be made by parties that an attempt shall be made for an out-of-court settlement, amicable settlement.
In the meantime, both parties should not cultivate the land.
Again and again.
Because that cultivation part comes, then they may fight each other. Physical fight may be there. That's why.
Why should they cultivate the land?
Yes, no, I'm not saying that because
She's very much aware of everything, your Lordship. She's not staying, but everything. He's aware of everything. My learned friend is aware of everything.
That's what I'm saying. I will be parties, not party. If and one of the parties, any one of the parties, both a party allowed to cultivate, then there may be a problem.
Status quo, not cultivation. Yes, Thom. We're dealing out of the score. And an out of court settlement be attempted by them.
Your Lord, may I please, Your Lordship, in the meantime, Your Lordship, both the parties are village people, Your Lordship. I do not know whether education is there. So some district council,
Yes, wait for the other.
someone should mediate,
Yes,
otherwise.
yes. But I don't know if there's any mediator, trained mediator in Tura.
And whoever.
They can suggest some officer.
That is the thing, Your Lordship. Otherwise, both of them are.
They may appear before the revenue officer. No, we'll apply. No,
There is a mediator lordship.
I think we'll make them appear before one of the judicial officers from the normal judiciary.
Yes, that can
Normally, that is
yes,
the thing.
that will be better.
Or Your Lordship in the.
Yes.
West Garo Hills.
West Garo Hills, Your Lordship. Or Your Lordship, mediation of the High Court, that will be better, Your Lordship.
You'll all come all the way here for mediation.
Because
that side also there is mediator on the last occasion where there was a lot at the lot. One particular judge who was conducting, he said, if you have mediator, we are having it in Garo Hills also.
I'll conclude order. I'll send them this.
Yes, Your Lordship.
Yes.
I'll find out from the High Court.
Yes.
Better it will be judicial side.
Yes,
judicial.
Your Lordship. And some time may be granted for mediation.
Otherwise, orders they already there. Will go back.
Yes, Your
Then
Lordship.
again, will take. By the time you'll be retired also. By the time revisions we file again.
24.
And both sides will come for sure.
Yes, Your Lordship.
It'll never end.
This Sama will come, sure.
It'll come.
Much obliged, Your Lordship.
Most blessed, Lordship.
Where's the petitioner?
The additional affidavit.
Second case is together with Sunsa. Yes.
Yes, Your Lordship, as per the additional affidavit of the state, it is very clear, Your Lordship, from the map. And the legend is very clear also from there that the road, you can see, Your Lordship, in page number 7.
Affidavit?
Additional affidavit of respondent number 3.
Where are you reading from?
Yeah, page number 7, Your Lordship. With this affidavit, Your Lordship, and with this map, the legend is very clear.
My apologies, my lords.
No, it's okay. Yes.
It's very clear from this legend line here.
From?
Page number 7, Your Lordship.
Yes,
the legend line is there.
Legend?
Legend line. The red one, I think. It's not pink, it's red one.
BRO Road.
Yes. There's a small pink line.
Yes.
Not in PWD road. Not in PWD road, as per the legend mark. Pink line. And this dot red line is the border. So with this affidavit and with this map, there's a small pink line, vertical.
In the Bangladesh border?
Yes, next to the blue line.
Okay, yes, not.
Yes.
Yes.
It's this one, Your Lordship. And as per the pointer of the pink line, it says export road from Majai to Company
Yes,
Ganj, where 0 point, not in PWD road.
Yes. Yes.
So this clearly shows that this small road, this pink legend line is the private road of the respondent number 6.
Up to Majai from?
0.2. Umdut.
Yes.
This blue, and there's an export road from Majai to Company Ganj. The pointer is there, Your Lordship.
Yes, Mr. Paul. They said that on affidavit they said that this pink section is not maintained by them at all.
Therefore, that main question again comes back. We again back to the main question, Millet. That in view of the provisions of the Customs Act, Millet, whether export can be made from a private road.
And let the customs take a call on that. We'll close the matter.
Millet, you would have to decide that issue, Millet, whether that is permissible or not. It's a pure question of law. Your Lordships may decide it otherwise also, Millet, but it would have to be decided either way. If your Lordships recollect, Millet, what we had originally argued before your Lordships is that the Customs Acts provide, Millet, that only on notified roads there can be export.
Right.
Now, whether a private road can be a notified road under the Customs Act, Millet, is the legal issue that would have to be answered.
But the fact remains is that notified road is a private road. That's a funny.
It cannot be a private road anymore. The moment it is notified, that is the case before your Lordships.
But then the things that producers don't maintain it. So
they may not.
What will happen?
They may not maintain it, but the fact of the matter remains the classification of that road would then change into a notified road, and the moment it is a notified road, it would be obligatory for the state to maintain it.
Union affidavit also, Your Lordship, it can be.
I would only pray, my lords, before your Lordships.
Because how can the court decide this point?
No, my lords, it's only what is the factual situation would not be a relevant issue.
Situation is that they say that the customs.
The factual situation, in my humble submission, would not be a relevant factor once the law comes into play. Now,
not just facilitating it. It's just sending it through that, they charge the customs stations there itself.
My lords, the question is that once a route is notified under Section 7, whether, my lords, the classification of that road would continue to be a private nature or it would automatically...
Where's Customs Act, Section 7?
Give me Customs Act. We reproduced it in our writ petition.
What about other places where people make private roads all in this coal export?
That cannot be used for export, Millards. Because the export point, Millards, the customs come into play. Otherwise, anybody, Millards, in this part of the country, there are many parts where, Millards, the house may be in India.
So see what's happening here.
The kitchen may be in.
That fine. Now the road maybe is very bad. They make their own road for private land. It touches the customs point.
They cannot export
that
it.
Road is
My lord, they cannot export it in view of the categorical language of the Act.
Exactly. But then the...
I'll just take your Lordships to the relevant provision. My lords, if your Lordships kindly have a look at Section 7.
Yes.
My lords, appointment of customs, ports, airports, etc. Yes. The board may by notification in the official gazette appoint. My lords, C would be relevant for us, my lords. The routes by which alone, the expression is alone, my lords, goods or classes of goods specified in the notification may pass by land or inland water into or out of India or to and from any land customs station from or to any land customs frontier. So that answers the question, my lords, that I may create a private road to the edge of the border, but whether I'm permitted to export from that point, I'm not.
But there's no declaration under Section 7 regarding the route.
It is, my lords. It is notified under Section 7.
But that's the thing.
The notification is under Section 7.
Where is that?
I'll take your Lordships, my lords.
It's an affidavit of respondent number 1.
Page 10.
It's there. Even we've annexed it. I'll take your Lordships today.
Affidavit to respond number 1.
Your affidavit.
My lords, I have it annexure 4 of my writ petition, my lords.
15th of July, 22.
1 second.
What? The notification?
No, the affidavit.
No, but I'll take your Lordships first to the notification. Your Lordships would find it in annexure 4, page 29 of my writ petition. Your Lordships have it, my lords.
29 years.
At page 29, annexure 4. My lords, this is notification number so-and-so dated the 21st of November 1994. in exercise of the powers conferred by clauses B and C of Section 7 of the Customs Act 1962, the central government hereby appoints the places specified in column 3 of the table annexed hereto as land customs station for the clearance of all goods or any class of goods imported or exported by land from or to land frontiers specified in corresponding entry in column 2 of the said table. Now, the next one is important, my lords. Routes to specified in the corresponding entry of column 4 of the said table as the routes by which alone all goods or classes of goods may pass by land or inland water into or out of India to the said land frontiers. Now, under this, my lords, if I may turn your lordships to page 31.
Yes.
At page 31, my lords, your lordships will find Khasi Hills, Bholaganj, my lords, and under Bholaganj, entry number F.
One second. Yes.
Entry number F, my lords, Public Works Department, Bridle Path from Bholaganj to Companyganj. Now, once this notification under the statute, my lords, is made, declaring this as an official route, whether the, my lords, whether the road is maintained by PWD or not maintained by PWD, or whether it is traveling over somebody else's land, in my humble submission would be immaterial. Because this is the only route under which somebody is permitted to export. And the moment that...
Now, one thing, Mr. Mosika, yes. Now, see, the thing is that that road notifies us from Bholaganj
to Companyganj.
Now, this is in this map, as per the legend given, now Bholaganj is there circled. This pink one goes up to Exporter Road from Majai to Companyganj, right? So the thing is that now, this road is not maintained by PWD. Then who's... They're maintaining themselves.
We are maintaining.
Yes.
From time immemorial, your lordship.
My lord, my reply would be, my lord, lordship kindly sees the prayer in the writ petition, my lord.
No, let's go to the prayer. This is an interesting point. Now, if a route is notified, now what does it entail? You understand what I'm trying to say?
My lord, we have notified...
Suppose the route is notified by customs, like, does it mean that only that the custom identifies that this route should go through, irrespective of who owns it?
Exactly, my
lord.
In fact, the notice
says, who owns it, you know, like...
My lord, in fact, the notice says, my lord, PWD road.
That is what previous says is not maintained, see. Not in PWD road register. Export road from Majai Companyganj. Yes.
It says, my lord, 500 meters of PWD bridle path from Bholaganj to Companyganj. Lordship kindly sees page 10 of my affidavit, my lord.
So if your lordships are now to hold, my lords, that is a private road, this notification goes.
No, not necessarily, unless there is a challenge to this notification, my lord.
No, I am not challenging the notification.
My lord, they have the remedy, my lord. They can
this
challenge
notification will be
They
rendered.
can challenge the notification if they are...
No, why should I challenge the notification? I am saying, my lords, it is the moment there is a notification under section 7, my lords, the character of that particular path will change, that route will change.
My lord, Customs Department is no authority to declare any road as PWD road, my lord.
Yes.
This has been informed to the Customs Department and accordingly they have notified him, my lord. If there is some problem with the route, whether it is PWD or not, well, Customs Department has not declared anything, my lord, by this. This is a notification under section 7C.
No, I'm saying whether once it's declared, whether, you know, no one else has right over the road. It has to be, you know, a state-owned road.
That is what I'm submitting before your lordships.
Yes, what do you want to show me affidavit?
Page 10 of my affidavit, my lord.
That's filed on?
It's filed on 15th of July, 22, my lord.
Affidavit of R?
1.
Very interesting case. How is that little portion left out? And that road, where it belongs to the same ship or not? Yes, where are you reading from?
Well, I'm referring to page 10, my lord. This is the notification.
Yes.
At serial number 2, my lord, Bholaganj. A, 50 meters on the eastern side, 50 meters on the western side, 100 meters and so on. So we are not concerned with this.
It's a land custom station. Yes.
And B, my lord, 500 meters of the PWD bridle path from Bholaganj to Companyganj towards north, that is on the Indian side, from the gate at border fencing near international border pillar. So what I was trying to stress upon, my lord, is 500 meters of the PWD bridle path. So my lord, we have been informed that this is a PWD road. Accordingly, we have notified.
Without verifying.
And we are not required to verify, my lord. Because our declaration is under.
Now, if it's indicated in their notification that this road belongs to you, why not maintaining it then? So we will go to petition. This is just general, because writ petition will not cover whatever has been raised now. It's not cover, it's gone beyond the scope of writ petition. It's only in a point of interest. Now the thing is that a rule has been defined by the customs, correct? Okay, fine. Now rules been given customs and the map been given a PLUD now. Now there is a brittle path of PLUD. It goes up to company line.
0 point.
Okay, to 0 point. Right. That is the route which is identified. That the export should take place from this route. Now they have come in and said that that one portion of the road, why they are issuing these instructions or asking them to put stickers or pay a small toll for using that road, because the road is maintained by them. So in that at that juncture, the court said, okay, fine, who owns this road? If the custom says that it's a brittle part, and Mr. Paul has said that's notified under Section 7 that this is the route for transport, it should not belong to any private party, and so respondent number 6 will have no jurisdiction whatsoever to impose any toll for maintenance of the road. Okay, that is, it comes there. Now, when we ask for the required information, you have come up with the affidavit very clear with legend map saying that that small portion is not maintained by you. Then it's nobody's baby.
For the moment, if Lordship kindly come to para 5 of the affidavit filed by the respondent by the R1.
So that's the only thing. We are stuck there.
Lordship kindly come to para 5.
Yes. 5?
Para 5 of the respondent number 1, Your Lordship, yes.
There's no para 5.
Lordship, respondent number 1.
Union.
Yes, it goes from 4 to 6.
Lordship, I do have paragraph 5, Your Lordship.
My this court copy has the affidavit of position filed on 15/7/2011, sorry.
15/7/22.
Yes, it goes straight from para 4. That regards statements made para 3 or petition deposits as follows: A, B. It goes to para 6. What is the page missing here?
Number 5, para 5, page 3.
Oh yes, para page 3. It's reverse. Yes. Yes.
Lordship, from that first paragraph, Your Lordship, 5 sentence from below. Therefore, Lordship is with me.
5 sentences from below.
5 sentence from below, Your Lordship, in first paragraph of paragraph 5.
Yes, therefore.
Therefore, the road mentioned above, that is the public departmental bridle path from Holapan to Company Ganj, is to be notified road by which alone all could or class by line into out of India to the Bangladesh in this case. So, then Lordship, can you come to the affidavit filed by the
No, 1 second.
They say that it's a bridle path.
And now I said levity of tax on other assembly is notified, not in the scope, Section 7(1).
Then Lordship, can you take on board, Your Lordship, the latest affidavit filed by the state, Your Lordship, at page 55.
55?
Lordship, yes. That is the affidavit dated 16/2024. That
yes.
is road register of Meghalaya PWD road.
Yes, yes.
So and so, Your Lord.
Yes.
Kindly come to serial number 54, Your Lordship,
yes.
55, 56, 57. We have only 4 bridle paths, Your Lordship. That is the Maumlu Mosto bridle path, Terna Maulong bridle path, Maublang Haria bridle path, Footpath Walong Bairong to Maubang.
That means customer has to do a review.
Maybe, Your Lordship, at that particular time, the state was not consulted or was not taken into consideration.
While making the route.
Lordship, maybe, Your Lordship.
No, my Lords,
maybe it is.
If my learned friend finishes, my Lords, I'll just.
No, the customer has to do a.
My Lords, I am not on that issue. The issue is here, my Lords, is that once it is notified under Section 7,
even
and in view of the specific expression under Section 7,
any right. You're a private person.
I'm sorry.
Whatever it is, you're a private person. Now you've come. Your prayer and the petition is for whatever notices they've been. Now, livability or non-livability of private parties, that has to be decided again afresh. With, the customs will take a call now.
No, my lords, what I'm submitting before your lordships is something different. What I'm submitting is, my lords, irrespective of it, whether it was a private path or it is not a private path, the moment a notification under the statute, my lords, provides that it is the only notified route, the characteristic of that path or that road will change.
Where do you get it from?
Well, I'll have to satisfy your lordships on that, my lords.
So where do you get it from? That once it becomes, that is what this court's trying to find out.
My lords.
Whether it doesn't matter, they just identify a route, and if there's A, B, or C in the
my lords, your lordships will kindly appreciate. And if I may, my lords, there may be an existing road. In the process of expansion of a highway, my lords, if the highway is diverted, or my lords, a portion of that private road is taken in by the highway, my lords, whether that will still continue to be a private road or whether it will be part of the highway. Because it is a notified. The moment it is notified under the law, my lords, the characteristic of that road will change.
See, the only thing that this court exercise entered into was to see whether, the action respondent number 6 in putting certain restrictions in the transport.
My lords, the moment what I'm submitting for, that is correct in law or not?
Permissible because it's
a notified route.
Which notified route.
No, that, which is why I'm submitting before lordships.
Because as per the route, it says the bridle path. So if it was established that yes, this road is maintained by priority, then respondent number 6, it ends there.
My lords,
they have no right. But now the funny part is that they have come, so we don't maintain it.
The question comes, therefore the question I ask myself is, my lords, once the central government statute provides Section 7, my lords, and under Section 7, the central government has exercised its power and called a certain path, maybe wrongly bridle path. Whether it is open for the state to then say that we are not maintaining it, and some private party saying that we are maintaining the road, so therefore we are charging taxes.
As of on the ground, how's it going? Exports are going on?
Well, it's limited export now.
From last year.
There is limited export now, my lords, because with that matter pending before the Honorable Supreme Court, there is limited export.
With regard what Supreme Court?
Export of limestone to Bangladesh, my lords.
Major, minor.
How many matters from here before the Supreme Court do you think? From this court?
High Court, my lords? Not much, would not be more than 10, my lords. For Meghalaya, I think not more than 10. Pendency is not more than 10.
And service matters?
Which one?
Service, Union of India.
Union of India?
For Meghalaya, my lords, very few, very few.
I give opinion not to file SLP.
No, I'm not talking about this case. Because incidentally, I'm just talking, yesterday there was a meeting with the CGI. He said that, all those cases which are for the Supreme Court now, they're going to have a long look at Adalat. So they've asked us to, to identify the cases that are there, which maybe can be self-service or something, and to call the parties here, because the parties won't go there. So call the parties here, issue notices like, whether they can be settled, and so...
I don't think, at this moment, there are not more than 10 cases pending.
I mean, to transmit information to the Supreme Court, then these are the matters which, that can be taken up and disposed of.
Only some mining matters, the limestone and coal.
Mining matters, there are 4 matters, my lords, of mining. There is that one matter which was...
Boundary dispute matters there.
Boundary dispute is there. Then, my lords, that one matter regarding that forest land in Garo Hills, that matter is pending. Officers' profit. These are matters that cannot be settled, my lords. I don't think so. Private matters, I don't think too many matters are pending.
What about service matters?
I don't think any matter is going to Supreme Court.
No. So Assam Rifles?
No, none.
Union of India is hardly filing any SLPs there.
I tell them not to file SLP.
No, not question, not tell. It's just that the matters are pending, so there's an exercise now.
No, unless the...
Unless the orders of High Court, that if there are matters pending from, because you have states like, High Court of Chandigarh having 8,000 cases, and SLPs only pending for them. Other High Courts have 7,000, 6,000. That's the thing.
Meghalaya's contribution would be in single figures, my lords.
Because of the distance also.
Chandigarh
but all high value cases, yes. Yes.
So, my lord, as far as this matter is concerned, the scope is very limited, my lord. If they are still agreed with any action or our notification or our declaration of that road.
No, I am taking assistance of the notification of the respondent number 1, my lords.
But to interfere with that notification will...
No, I'm not asking for an interference with that notification. I'm saying, my lords, that is the notification. So once it is notified, the characteristics of the road change.
Well, that we have said in para 5.
Now, what about, suppose, what is the... what about the, that elevated conveyor belt that goes from... That's an export road also, that goes to Lafarge.
That came before your lordships also at some...
what is the characteristic of that?
That is again notified under the Customs Act.
But that's owned by the private company.
My lords, it was set up after permission from the central government.
But it's owned by the company themselves. That conveyor belt set up by them. But
well, that matter also had reached the Guwahati High Court. I'll have to just do a little bit of research.
That's one thing, because they are that is a private. You can see a private route, which they are running.
Lordship,
right?
Lordship.
The only thing they're doing is just paying.
One aspect will be clarified from here only. Page 10 of my affidavit. As far as Komora Chatak ropeway, this is covered.
And even the Komora ropeway, Your Lordship, is under our lease only.
That was, my lords, of that matter. If I remember correctly, my lords, Dr. Devi Pal had come and argued before the then Guwahati High Court with regard to
even
this
Lafaz
issue.
is covered. Page 11 of my affidavit. Areas covering the crusher, the warehouse, and the long belt conveyor of Mrs. Lafaz Umiam Private Limited up to the 0 point.
No, I'm saying whether they can whether they can notify private roads also. When it comes to the ambit section 7, whether if they notify, they can notify that that that's irrespective, except middle part, whether that can remain, remain valid,
Whether that will still maintain its private character, or, my lords, it would.
Well, it is there, my lord. If Lordship kindly sees at para 11, Lafaz has been notified, my lord, of my affidavit, or R1. That is a private land, my lord.
Oh, that is the only thing. No, see, Mr. Paul, what is trying to think is whether a route can be identified which goes through
Private land.
That is the only thing.
My lords.
That's the only thing.
My lords, what I'm taking it a little bit further.
You think that once it's notified,
Once it is notified, private thing goes.
That's what.
Because the expression is alone, my lords. Because the expression is alone.
Itself, my lord. See, serial number 4, Lafaz belt, my lord, at page 11, lord.
Oh, sorry, I'm looking at the petition.
Shalabazar.
Shalabazar.
We'll do a little bit of research and come back to your lordships on this.
Very interesting, because yes.
Yes. In this page 10, in the affidavit of the union, in para 2, it says the ropeway of MS Komora Limestone Mining Corporation. The same MS Komora Limestone Mining Corporation. I have a lease document here which is addressed to the same of Sora, a land lease agreement in 2010, which is still a running lease.
This
till
what
now
they're reading is section 8.
No, that's different.
Section 8 is
I'm
different.
no. See, only about I'm just whatever might be sort of ambiguous repetition, but just for the general knowledge.
Well, what they're reading now is under section 8.
What Mr. Paul submitting that once it is notified as a route, that means no other party has any right to to do anything on that road, maybe check or regulate. Or
That I'm in my humble submission is not correct, my lord. My lord, even section 7 notifies page 32 of the writ petition, lords, you kindly see, page 32 of the writ petition.
Just we're just beating around the bush. Yes.
Page 32, serial number 27, my lord, Shalabazar.
27.
Serial number 27, page 32.
Yes.
And then subclause D, my lord, the 7-kilometer long elevated conveyor belt of so and so, 100% export oriented, originating from the crusher site.
Exactly, well, it's a 100% export oriented unit.
40-meter wide strip of land comprising villages of Flankaru, Bumantila, and Umkhaba on the west, and so and so, so and so, so and so. On the
My lords, the important word is a 100% export oriented unit.
That will not make any difference.
It will, my lords, because export is a matter which is covered by the central list, union list, my lords. It is only covered by the union government can permit export. So once the union government gives permission to somebody to set up a plant in India which is a 100% export based unit, my lords, no part of that is actually being sold in India. So for the purposes of export, my lords, a route is mentioned. So that route may be...
The plant is situated somewhere else, my lord. Here we are talking about the export route, the 7-kilometer long export route.
And then you just find out.
We'll do some research and get back to your lordships on this, my lords.
Yes, you do research also.
Close the matter, giving them
We
liberty.
can close the matter. We can close the matter next day.
Document only, Your Lordship.
Yes, after hearing some length, Mr. Kapil, please is allowed 2 weeks' time to obtain further materials and information with regard to the status of a route notified under Section 7 of the Customs Act and as to its character. Yes.
I'm grateful.
Yes, that's an interesting point because...
Yes, otherwise what would happen is, if I have a house next to the border, what I can do is I can start exporting for my land also.
No, you have a road next to the border, not a house. Then you can
no, my lords, because the central government is now saying that we've just notified, we were informed, whether it is private, whether it is government, we don't know. So tomorrow they might notify my land and under Section 7 and say that we can export.
House, my lord, then definitely, I think.
So it will continue to be my house, my lords, and I can export from there.
Yes, next matter.
25.
Yes. Where's the other side? There was some talk settlement here last time. Who was saying that?
Not that I'm aware of, my lords.
Where's the other side?
Mr. Datta is appearing from Guwahati, my lords, in this matter.
It's not voting day today, correct? No.
No, it was yesterday, not today. This matter has been heard by your lordships at length on numerous occasions, my lords. This is that GST matter.
Yes, or that escrow account.
Lordships. After that, we had filed the compilation of all the correspondences also, my lords, and they had provided that check. Yes, my lords, there's a compilation that is there. Something like this.
Okay.
The entire correspondence from day one
No,
to...
they had some submission to make with regard to, because...
That check, my lords.
Yes, yes.
That is clarified from the statement of account.
We have to post it, they're not here, we have to post it another day.
Have it after 2 weeks, man.
2 weeks? Okay, after this matter of 2 weeks, yes. None of you will have this matter of 2 weeks, yes.
Obliged.
26.
Please, Your Lordship. Last occasion, Your Lordship, I made a submission before this Honourable Court that we are actually relying on the notification, my Lord.
Where's the notification? Regarding what is this matter about?
This is in regard to pension matter, my Lord.
Ready? Very good.
If that notification is there before Lordship.
Where's the notification? You didn't type it out?
No, type copy is there, my Lord.
Yes.
Here, my Lord, the...
Lordship, prayers at page 13.
Excuse me. Page 13?
Page 13, my Lord.
You appoint ad hoc from 91?
Lordship.
Oh, sorry, 92.
92, my Lord.
92, Lordship.
Then he was subsequently regularized in the year 1996, my Lord.
On? In?
1996.
1996. So only for the period 91 to 96?
Yes, yes, my Lord.
Where's that, what is that? There's, apart from this notification, there's something, there's another notification also.
There's another notification. There's only two notifications. 1983 notification is there, my Lord.
Now you appointed under, let's see appointment order. Appointed against vacancies.
Yes, my Lord.
What's your appointment on page 29, Lordship?
29 is the type copy, my Lord.
Okay, existing vacancies. Then why it shouldn't be given? Mr. Karwanam?
Lordship.
Yes.
Lordship, so basically, Lordship, this matter has, he's raised this issue after 3 decades, Lordship, after 30 years. Lordship.
Would it have a bearing on it? He's drawing pension now.
He's already bearing.
Does it have a bearing on the calculation of the pension payable to him if you put it in increments? Only for increments, correct?
Lordship, out here, he just...
Increments, madam.
Only for increments. Not for, he was paid a regular, he must have paid a regular scale of pay when he was ad hoc also. He wasn't paid regular, but only that regarding his increments he's coming here, correct?
Lordship.
So
That
what
was
is
not
the,
paid, my
what,
lord.
what
That
is
is
the- what is-
actually-
have you quantified the amount that he should have got?
Lordship. No,
Have
no,
you
my lord.
quantified? Then?
No.
Have you quantified the amount? I should have been given this increment. Like these increments I have not got.
That has not been calculated, my lord. That is
Why?
my case.
You have
Because
calculated?
this was not even calculated, my lord. They have only calculated from the date of regularization, my lord. That is my case. They are not even calculated from the year of 1992, my lord. From the date of my initial appointment as an ad hoc employee, my lord. Despite the notification, they're basically going against their own notification, my lord.
But you've come after how many years?
I've come, my lord. I've raised this issue, my lord, in the initial writ petition also, my lord. There also they have categorically stated that I will be entitled only from the date of regularization.
When was that?
That order, my lord, is
That repetition also
that reflected
was
also.
filed in the 1000.
No, that is because I was
After
not paid
30
pension, my
years,
lord.
Lordship.
I was not paid
After
pension, my
30
lord. That is
years.
why I have to come. No, that is after, my lord, after my retirement, my lord. They have not calculated the initial appointment, my lord. The date of my initial appointment.
My lord.
So that also was agitated. That also was agitated before this honorable
Okay,
court.
fine now. You are saying that you're entitled to certain increments from 1991, 1996.
Yes, ma'am.
Right, there are 5 years for which you were paid regular scale of pay because you are regularly appointed, I mean, by selection process, and you are allowed to ad hoc against vacancies, correct? So you paid regular pay scale you've been given. Now the only thing you're saying is that the increments have not been paid, correct?
Lordship.
Now regular pay was paid from the time that you
They have paid a fixed pay, my
No,
lord.
no, no. Were you paid from the initial appointment?
Lordship, fixed pay, my lord. They have paid a
Whatever
fixed
is that
pay.
time,
Yes, ma'am.
whatever pay was permissible at the time you were paid that pay.
Lordship.
Then you have no grievance with that.
Lordship.
Now, after 96, you didn't agitate. When you start first agitating that my increments were not paid for?
They actually agitated, my lord.
When?
They agitated during that point of time, my lord.
When?
But that was not considered.
When? Where's that? Is here?
No,
Materials here.
initially what has happened, my lord, if your lordship comes to...
Sit down, Mat Karan Lang. Relax. Yes, yeah, your time will come. Yes.
If lordship comes to page 20, my lord, this is the
Yes.
advertisement.
No, I don't want to go to. I want to know when did you first realize that, oh, my increments are not paid, although I've been paid the regular salary, so I should agitate for that. When was that?
No, that is during my writ petition, my initial writ petition, my lord, when I filed the initial petition, my lord.
2022.
Possible? Petition, my lord. 2021, my lord. File an initial writ petition, my lord. This,
Before
this
that,
is the second round of
any
litigation.
representations that you sent?
Lordship. There's no representation to my
Before that, you were sleeping. You didn't know you were entitled to that.
No, because we were not aware about this notification either, my lord. We came to about this. We came.
It is notification. First one is 74
Lordship.
and around 83 before your
Lordship.
point also.
No, but that is what, my lord. We were not aware about this notification, but the state government was aware about their own notification, my lord.
See, but after how many years you've come? Is increment a continuing right?
It is, my lord. His pension
How?
is continuing right, my lord.
Pension is continuing right. Is increment a continuing right? Or have you waived your
No,
right?
but they are going against their own notification, my lord. That is a continuous wrong, my lord.
That can be possible also.
If it is a
you have
continuous
waived your
wrong, my
right.
lord, then
By-
delay and
by
latches will not be
sleeping-
applicable,
By
my lord.
sleeping over your rights, you waive that right to that small increment you're supposed to get. You
Because
waived
we
your
were
right.
not aware, my lord. At that point of time, we were not aware, my lord, about this notification. We came about this. We came to know about this notification only recently, my lord. That is why we brought this notification before this honorable court, my lord.
So what do you want the court to do? Grant you that, what is the quantify? Can you quantify it? What agreements were given to other similarly situated employees who were served in this?
No, other similarly situated persons, what has happened, my lord? When the date of initial appointment, they were regularized from that day itself, my lord. So they had no grievance
From
whatsoever.
92, some of them.
No, after they were appointed in the year 1993-94, my lord. That I have already.
And what increments were they paid? For
No,
the
they were
use of-
paid the regular pay, my lord.
Increments, what increments were they given? How many increments were they given?
That I'm not aware of.
Now, how many increments do you think you're entitled to between 91 and 96? Or 92, 96?
That I think that has to be calculated from their end, my lord.
Suppose there was no increment during the period. It's possible also. You don't cross efficiency bar, there was no increment. That means the representation becomes zero. You're not even aware of whether increments, other people were awarded increments or not.
They were awarded, my lord.
Sure.
Yes, my lord. Why? Because from the date of initial appointment only, they were regularized, my lord.
Let's see your affidavit.
Respondent.
What kind of affidavit is this, Mr. Karuna?
My lord.
What kind of affidavit is this?
My apologies, Lordship. I didn't get the thing. What?
Have you assessed the entitlements?
No,
What
Lordship.
standing delay?
Lordship, I didn't get instructions
Why?
from the Lordship. Because, Lordship, this matter, Lordship, he doesn't have any right when he accepted
Forget about the sleeping. There's no question of acceptance of employment. Once they give an ad hoc, suppose even work charge also, some cases you're entitled to, to get, the revised pay scale or whatever. Fine. Now, increments, you're regularized from 96. Yes, and then what does the notification say? It says that see the continuous offshoring appointment will count towards leave, increment, pension, etc. That is what.
Lordship, can I take your Lordship's prayer again?
You have to see the prayer. I've not seen the prayer.
Lordship, this is not about increments, Lordship. Matter is not about increments. It's about grant of pay for the date of initial appointment, Lordship. May I read? In the premises aforesaid, it is most respectfully prayed that your Lordship would be graciously pleased to issue rule, call for a cause, and after hearing the parties, be pleased to direct the respondents to grant the regular scale of pay to the petitioner as advertised in the advertisement dated 25/01/1991 from the date of his initial appointment, that is 01/08/1992, as his period falls under the qualifying service of the petitioner. Lordship, this is not about increments, it's about granting him pay for a thing. Because when he was appointed in 1992, Lordship, he was given a pay of 900 rupees.
Lordship has discretion to mold the prayer also, my lord. I'm relying on submission. I'm relying on the Supreme Court judgment, my lord.
Mold the relief is in certain cases only.
No, but it is against their own notification, my lord. It is a law, my lord, under Article 13.
See the following. Who is this? Now, what is order page 31? Before that, the appointment was...
This is regularization, my lord, page 31.
Okay. See, you accepted this terms of appointment. Lump sum fixed monthly rupees 900 without any allowance. Then after that, there was a selection in, after you passed out the training.
Yes.
Then you were regularized from 96 and given regular scale of pay.
But if Lordship comes to next page, my lord, page 33, these people, they were not sent for training, my lord. From the date of initial appointment, they were regularized, my lord. Lordship, page 33, my lord.
You meet them party?
I did not meet them party. This is just for reference only, my lord. We are not aggrieved by them, my lord.
No, the method of appointment is totally different. You can't equate yourself with them.
Lordship.
Sorry, Mr. Mumin. Yes.
Lordship.
You asked for that you only asked for increments that you appeared regular scale of pay from the time you appointed.
As per the advertisement, they were supposed to pay, my lord, from the regular scale of pay. That was also a regularized post, my lord, but they have given appointment on ad hoc.
Appointment before was purely temporary, that means. It was not even under, it's not under 3F.
It's ad hoc, my lord. It's clearly mentioned, my lord. Advertisement clearly mentions that it's a regular post, my lord. But while giving appointment, they have given appointment on ad hoc. But be that as may, my lord. But even the notification, my lord, clearly speaks, my lord, that if there's a continuous service as an ad hoc employee, that should be calculated for increment for pension, my lord. That was not done. They are going against their own notification, my lord.
Was the earlier order passed in earlier writ petition?
Page 45, my lord. Annexion I.
Okay.
There in the affidavit, they have stated categorically, my lord.
Now, it's not disputed. You have.
Not disputed that the petitioner was regularized in service in 1996. As such, the petitioner shall be entitled to service benefits such as pension, etc., only from the date of regularization. This word itself goes against their own notification, my lord.
Now, your prayers for regularization from the date of initial appointment.
Lordship.
In this case, correct?
Lordship.
Right or wrong?
That is right, my lord. I'm not disputing that.
No, Lordship. It's for grant of pay of as per advertised. Lordship, not for regularization from the date of initial appointment.
From the grant of pay, my lord.
You should ask for regularization the date, you know. The regularization, you should, like this order, you should have challenged that time when it was regularized in 1996, that our regularization should be from the date of ad hoc appointment. That's not done.
This is not about regularization. It's only about increment, my lord.
Then only increment and not
increment
pay.
pension for pension benefits, my lord.
See what?
Because once I have been appointed as an ad hoc employee, my lord, my service as an ad hoc employee should also be counted for pension and other benefits. This is what the notification talks about, my lord.
You read the notification, okay? You read it, even though there are certain notifications after that also, but they made certain exceptions. Clarify the period of continuous officiating upon regulation 3F or ad hoc appointment of government servants will count towards leave, increment, pension, and not on your scale of pay, where when your terms of appointment clearly say that you're not entitled to any allowance and you pay a fixed pay. The terms of your engagement totally different. After you regularize, after you finish your training, you'll be given regular scale of pay. That's why. So you should ask for regularization, you know, with from the date of 1992, initial appointment at ad hoc. The
Lordship, if
Lordship
Lordship
should be considered regular.
If I may be allowed to read, my lord.
And then now you're asking for your, how can you ask for your pay?
If I may be allowed to read, my lord.
This notification will cover only your other benefits, leave increment and, you know.
Leave increment, pension, etc., my lord.
Yes.
Says, my lord. It's clear, my lord. It is therefore clarified that the period of continuous officiating appointment under Regulation 3F or ad hoc appointment or government servants will also count towards leave, increment, pension, etc. on their appointment having been regularized.
Okay, then here order. The incompetence with petition then. Yes. Have you annexed the notification in the writ petition?
No, I tried to, my lord, because Lordship, last occasion I sought your permission, my lord. Lordship, it's not required. So it's already reflected in the order also.
Okay, take down. The writ petitioners. How many numbers? Just one writ petitioner?
Yes, my lord.
Is before this court praying for grant of regular scale of pay from the date of his initial appointment, that is 1/8/1992. As ad hoc in ad hoc service of Gram Sevak against existing vacancies. So, Mr. E.G. Moomin has submitted that the writ petitioner, after entering to service in the year after being appointed in 1/8/1992, was thereafter regularized in their services with all attendance service benefits on 19th August 1996. And we have retired when?
I retired, my lord, 31st December 2018.
And has since retired on 31st December 2018. Stop. It has been submitted that as per Rule 10 of the Meghalaya Civil Service, you are citing the pension rules 1983. The qualifying service of a government servant should commence from the date he takes charge of the post to which he is first appointed. It is substantially or in officiating or temporary capacity. Stop. Further, in support of his case, the council has produced 2 notifications for accounting of notification dated so and so and so and so, for accounting of the period of officiating appointment or an ad hoc appointment towards leave, increment, etc. He therefore submits that the petitioner, having been temporarily appointed on an ad hoc basis since 1992, his services are to be counted from that date itself for the purposes of leave, for purpose of increments and pension. Stop. Next paragraph. Oh, sorry, Mr. Anything to say?
Lordship, here we have already issued this PPU also in the year 2021. So, Lordship, if anything, is there any outcome of this writ petition? So, we'll take steps and expedite the matter.
Mr. H. Karwanlang, then additional senior advocate, has at the outset raised strong objections on the grounds of delay and acquiescence. Stop. He submits that it is only in the year 2021, in connection with non-payment of pension, that the writ petitioner had approached his court, and before that had never agitated for the relief that he is now praying for. Stop. He further submits that the terms of appointment by way of the order dated 1/8/1992 has clearly spelled out the conditions which the petitioner on entering employment had accepted. And as such, at this late stage, cannot turn around to demand service, to demand such service benefits which were not permissible at the time when he entered employment itself. So, with regard to notifications, what do you have to say?
Lordship, these will not be applicable in this case, Lordship.
He further submits that by the notifications placed by the counsel petitioner will have no application, inasmuch as the pre-entered petition is for
grant of
regular scale of pay as advertised in advertisement dated, as far as advertisement stuff.
And now with regards to leave increment.
And further, that these notifications deal only with entitlements to leave increments and counting of offshoring appointment towards leave increments and pension. Next, by approval and counsel for the parties, approval of the appointment order. Approval of the appointment order
orders at page 29. Dated
yes,
on
on
1st of August
1992. Shows that the writ petitioner was appointed in the office of block development officer on a lump sum fixed monthly salary of ₹900 without any allowances, subject to the terms and conditions. Several any allowances. The copy or the appointment order being relevant is reproduced here and under. Annexure 3 are you? Calculation. Where's the advertisement, Mr.
Advertisements at page 17, Lordship.
Page
17.
Page 17, my lord.
You applied person's advertisement?
Yes, my lord.
Where's Gram Sevak? 2 posts Gram Sevak.
Lordship. My lord.
The thing is that you have not agitated, but you have a certain amount of right. The only thing is that you quantified, because you have not quantified it, that's why. Otherwise, you would have just given an amount, you just give it to you, without counting towards your service benefit, some token amount can be given, that's all. Otherwise, on your prayer and you have not made out any case. But considering that he's retired and
Lordship,
he's given 4 years of service. Anyway, Tom. Yes. It can be seen from the point order that the writ petitioner was well aware about the conditions of temporary employment that entered into, also as to its emoluments. Which, however, on being regularized on
1996, my lord.
On 1990, where's the authorization?
Page 30, my lord.
Sorry. What about the conditions and terms of appointment when he entered employment? Stop. Thereafter, where's that annexure?
Page 30, my lord.
Annexure 4, Lordship.
Thereafter, Annexure 4. Yes. Thereafter, the services of the petitioner on its completion of training was regularized, and he was given the prescribed scale of pay along with other allowances as admissible. Stop. And he continued as such until his retirement. The next paragraph. From the facts above from the facts above and the materials on record, it is from the red petitioner had at no point of time agitated for regularization of his services from the date of his initial temporary appointment. On 1/8/1992, and in fact had accepted the same. Stop. And I agitated for regularization. Of his services from the date of initial appointment, or that the same be taken to account as a period of qualifying service for any other incidental service benefits. Stop. In the instant petition also, the prayer of the petitioner is only for a direction to the respondents to grant a regular scale of pay as advertised, advertisement dated 25/1/1991. As submitted by the Additional Senior Advocate, the applicability of the notifications also is in question, inasmuch as the terms of appointment of the petitioner and the conditions of his term of appointment, the petitioner, which were accepted, will be of no assistance in furthering his case. Stop. Even by the incident petition, the petitioner has not sought for any direction for consideration of regularization of his services from date of initial appointment, and in fact has only relied upon notifications which deals only with increments which may be payable, or even includes increments. Stop. In this view of the matter, what should we do?
Discussion, Madam.
Ended. In this matter, in view of the incompetent prayer, and that the petitioner never agitated for realization of his services from the date of his officiating appointment, no relief can be granted presently. And the petition is closed and disposed of.
Hello, Lordship.
Much obliged.
Item 30.
Yes, may I please, Lordship? As per the learned senior government advocate, Madam Sheila has informed me she has some meeting, some accommodation she is.
I'm praying for some accommodation. I was informed that Madam Sheila has been called for a meeting with the Honorable Chief Justice.
I pray, my Lord, maybe Monday, my Lord.
What's the matter? Salary?
No, my Lord. My Lord, there is a 2 date of birth recorded in my service book, and they have issued an order whereby I was given retirement in 2022, my Lord. So as per school certificate, as per the other records, my actual and correct date of birth has been recorded in the service book as 24th January 1967, my
As
Lord.
per your school certificate, which date is it?
My Lord, 1967.
Correct one?
Correct one, my Lord.
Then we'll go by that.
My Lord, yes, my Lord.
After 1 week.
My Lord, my Lord. Highly obliged.
As our commission sought on behalf of the senior advocate, this matter for 1 week.
Highly obliged.
31.
Lord, I'm praying this matter will be taken up on Friday, my Lord.
Today, on maintainability, such furious argument now, the senior is not in town.
Well, she is in town, my Lord. So today it's some difficulty, my Lord. So on Friday.
Friday is difficult. Friday is a rush day.
Then, my Lord, next week, after 2 weeks, my Lord.
After 2 weeks, not Friday, after 2 weeks.
No, next week there will be difficult, my Lord.
Yes, Ms. Adata, on behalf of the petitioner, prays that the matter be taken for 2 weeks.
After 2 weeks.
But he has allowed this up to 2 weeks. I always thought that this matter be taken up. Is that Nehu matter, correct? Mr. Sen's not there? Yes. Gani both to Pramilish.